Senate File 2680, Senator Lass.
Madam President, Senate File 2680 provides for a penalty enhancement for an assault for an assault that is motivated by bias. Under current law, if you commit a misdemeanor level assault that is motivated by bias, there is an enhanced penalty that obtains. In this case, a misdemeanor becomes a gross misdemeanor level, so the enhancement is from 90 days to a 365-day maximum penalty. Under current law, if you are charged with a stalking crime, it is a gross misdemeanor crime with a 1-year maximum penalty, but if it's motivated by bias, it becomes a 5-year felony. So a 500% increase in the maximum penalty if the stalking was motivated by bias. Theft crimes that have enhancement not for bias but for reasonably foreseeable risk of bodily harm, the enhancement goes from either 90 days or 1-year misdemeanor gross misdemeanors to 3-year felonies. If a sex predatory conduct crime is charged out, the predatory conduct aspect of it increases the penalty by 25%. And if terrorism is a motivation, the penalty is enhanced by 50%. What the bill before you does is proposes to enhance the penalty for felony-level bias crimes by 25%. Actually, a much lower enhancement than for the misdemeanor, gross misdemeanor enhancement, and for stalking enhancement. And what's being handed out to you, members, is a news article having to do with the case that brought this issue directly to my attention and why I initiated this bill. In Anoka, within the last year, there was an assault at a restaurant where a woman who was speaking in her native tongue, Swahili, was speaking to her family in a booth in the restaurant. And the people who were in the booth next to her were offended by her failure to use English and said, when you're in America, you need to speak English. And there was some back and forth about this, and eventually the woman that was offended by it stood up, took her beer mug, a very heavy mug, and slammed it into the face of the woman who was speaking in her native language with her family, who, by the way, not that it matters much, speaks English very well. You can see from the picture the damage that was caused by this assault, and there was absolutely no question but that the assault itself was motivated solely by the fact that the victim was speaking a foreign language. Bias. In the bill, as in other portions of our statutes, a bias crime would be where the violation is because of the victim's or another person's actual or perceived race, color, religion, sex, sexual orientation, disability, age, or national origin. The Anoka County Attorney's Office determined that they could not prosecute this crime as a bias crime because there was not specific language in the felony-level assault statutes to allow that bias enhancement. There is, as I've already noted, the language in the misdemeanor assault statute that allows a crime to be enhanced because its motivation is bias. And there's a very good reason for us having certain offenses enhanced because of the motivation being bias. It's because the crime is committed not just against the individual victim, but in a very real sense against society as a whole, and certainly against the larger community of which the victim is a part. In this case, the national origin of the victim. So all those who are perceived to be from that national origin are victims of this assault crime. And in a broader sense, all of us who find that assaults motivated by bias are particularly offensive and egregious, and wish to send a message that they, of all kinds of assaults, will be tolerated even less. We are all, in a sense, victims of that bias-motivated crime. Indeed, many of us would, under certain circumstances, fall into a category that is recognized for special recognition as a bias crime had it been the basis upon which we were attacked. So this bill identifies the felony-level assault crimes as those which will also be enhanced by 25% if the crime is motivated by bias, and it would be the responsibility of the prosecutor to prove beyond a reasonable doubt to the satisfaction of a unanimous jury that this element of the offense was present, just like they would have to prove the other elements of a crime. For that reason, members, I ask for your support, and I'd be happy to answer any questions.
Is there any discussion? Senator Newman.
Madam President, will Senator Latz yield?
Senator Latz will yield. Senator Newman.
Thank you, Madam President. Thank you, Senator Latz. The maximum penalty increase of 25% strikes me as being, a bit harsh. If you could explain to us how the enhanced penalty would be imposed, and by that I mean I'm thinking more along the lines of procedural rather than substantive. But is this something that's then going to fall into the sentencing guidelines and it would be determined, or is there going to be a certain amount of judicial discretion involved with the court in imposing the sentence? And I ask the question because it's subject to a maximum 25% increase longer than the maximum penalty otherwise applicable, so it seems somewhat vague, and I just want to have some guidance as to how that maximum penalty increase is going to be actually applied. And I hope I've made my question somewhat clear.
Senator Latz.
Madam President and Senator Newman, on line 8 of the bill, it identifies the 3 felony-level assault statutes to which this would apply. The first one, 609.221, is a first-degree assault. It is currently a severity level 9 offense, maximum penalty of 20 years under current statute. So a 25% increase in the 20-year maximum would make it a 25% maximum. Under 609.222, that's a second-degree assault. It's currently a level 6 offense. It is a 7-year maximum penalty when a dangerous weapon is involved and when there's substantial bodily harm as well. It's a 10-year maximum penalty. So the 25% enhancement would then lengthen those maximum penalties as well. Under 609.223, it's a third-degree assault. It's currently a severity level 4 offense. If there's substantial bodily harm, it's a 5-year penalty, maximum penalty. There are a few other categories in there. If there's a pattern of child abuse, if the victim is under 4 years old, for example, then those are also 5-year maximum penalties. Again, if they're motivated by bias, you would add 25% to that. The Sentencing Guidelines Commission would have within their authority to evaluate the enhanced penalty and make a decision whether or not to change the severity level. That would be the kinds of things that the legislature has delegated to the Sentencing Guidelines Commission to evaluate, but we don't know for sure exactly how they would approach that. But again, that would be the maximum penalty, which means as a practical matter, it may affect the length of probation if a person's convicted of it. and it may affect their sentence, but as you well know, Senator Newman, it's rare, exceedingly rare, that an individual is actually sentenced to the maximum penalty under the law, unless they choose to execute the full sentence themselves, which does happen on occasion. But typically they would be sentenced to some proportion of the maximum penalty, and then they would be on probation for an extended period of time after that. So it may have an impact on the actual sentence, but you couldn't say for sure that it would be a 25% increase because the actual sentence would still be left to the discretion of the sentencing judge.
Senator Newman.
Thank you, Madam President. Will Senator Latz yield?
He will yield. Senator Newman.
Thank you, Senator Latz. I didn't hear the last sentence that you spoke, but I think you said it was up to the judge to determine whether or not to depart and the extent to which the judge would depart up to a maximum of 25%. Is that correct, Senator Latz?
Senator Latz.
Madam President, Senator Newman, it technically would not be a departure. The maximum sentence would be lengthened. The actual sentence would be up to the judge. If the judge has all the sentencing discretion, or if there's a plea agreement, that could affect it as well. But it would not technically be a departure from the guidelines sentence. It would be an element of the offense, and presumably the guideline sentence may be adjusted to reflect that there's this additional element, a longer statutory maximum penalty, which may affect the Guidelines Commission's decision as to where to place such an offense in the grid, which carries with it the presumptive sentences. It might have the effect of someone being sentenced at the top of the grid instead of the bottom of the range in the presumptive range as well. But it might also have the effect of changing the presumptive range if the Guidelines Commission were to determine that if it were bias motivated, be a severity level 10 instead of a severity level 9.
Thank you, Senator Latz. Thank you, Madam President.
Senator Abler.
Thank you, Madam President. It's horrible to hear about these kinds of stories, and I just want to point out to members it was in Coon Rapids and not in Anoka. I don't feel any better about that, but I do represent the restaurant, and I have not met Ms. Jama, but I think these sort of things happening is just absolutely horrible. And if they're paying attention today, I hope that they sense that this body is interested in her being here. We're happy she's here, and embrace her and her family who are going to stay here, and that the outcome of this vote, however a person votes today, is not any indication of how they feel about her being here or not. I have some concerns about this bill, actually, and I won't ask Senator Latz to yield, but I'll just say them, and then the bill will move along. It's an easy bill to vote yes on, and why wouldn't you, to protect Ms. Jama from these sort of horrible things. By the way, Ms. Jama will not be benefited by this bill, frankly, I think that people who do these things are horribly ignorant and wrong, and they don't give a thought about what is going to happen to them in terms of enhanced penalties or not. They just don't get it. I had a campaign recently, which you all get to join the campaign trail soon. There was a lot of misunderstanding about these new Americans who have come our way. People do not understand that they just didn't come here because they were hoping to be in a new country. Ms. Jama and others have come because if they stayed in their country, they would be killed or tortured or burned in a fire. And they came here leaving the homeland that they love very much to come be a part of this country. And as I've met literally thousands of them over the last couple of years, I am so happy that they're here. They enrich our country. Both just Somalis, Cambodians, Hmong, and so many others who have, Ethiopians, others who have come
Just
our
a
way.
minute, Senator Abler. Some members can't hear, so would we please keep the noise down? We're on our last bill, so take your conversations off the floor, but stay close by to be available to vote. Please continue, Senator Abler.
Madam President, I wish I were more spellbinding for people so that they would feel like they should be transfixed by my comments. But I think as we go forward, and I'll tell you the number one thing I heard at the door was concern about the presence of some of these groups. People do not understand. And I'm going to vote no today, not because I don't care about Ms. Jama, but because the better way is to help people understand. To say, how could you not like this person? How could you not see the beauty this person brings to our country? How God created this woman with her family, and here she is after just a whole horrible time of trial coming to this great country of ours. And I think, however you vote today, please vote, obviously people will vote how they feel it. But the only way to stop this is to build mutual respect and appreciation and even admiration for their cultures that have come our way. We're all a country of immigrants, Madam President. My last group came from Ireland around the 1900s. My earlier group came, we fought in the Revolutionary War, Sons of the Revolution. But we're all new here, and we all share this place. And so I hope that we can put a true stop to this and urge members as they go forward, vote how you like on this thing. I'm not going to criticize either way. But for me, my goal is to help my constituents and the people of Minnesota understand the beauties of our great melting pot that we have and the joy and the privileges we have in this country. Thank you, Madam President.
Thank you, Senator Abler. Are there any other comments, amendments, or questions? Any final comments? Senator Westrom.
Madam President, a question for the author.
He will yield. Senator Westrom.
Madam President, Senator Latz, if the punishment isn't stiff enough on these crimes, why don't we just raise the threshold or the punishment across the board? Because an assault is an assault. If we think it's too low, why don't we just raise it across the board rather than carve out certain areas? Because if a prosecutor has a 20-year max, doesn't mean that they're going to get a 20-year sentence under the discretion of the prosecutor and in other circumstances, anyways. And so, why don't we just raise the bar on all of them so the crime has got a tougher penalty?
Senator Latz.
Madam President, Senator Westrom, the reason is that an assault is not just an assault. Most assaults are motivated by just an anger or an animosity or a particular topic of dispute between individuals, or they're affiliated with an attempted theft or something like that. But when the assault is motivated by bias, it's not a normal assault. And it wouldn't be appropriate to raise all of the penalties in Minnesota to apply to, the kind of a bar assault that's because two people who were drunk got into a dispute over, who's going to pay the check, or someone looked the wrong way at someone else's girlfriend. An assault that's motivated by bias is particularly corrosive against the entire community. It's a message that the perpetrator, the offender, is trying to send not only to the victim, but to many others, that they're not welcome here, that they are somehow less as a human being because of the color of their skin or their disability or their nationality, their ethnic background. Any of those reasons, those we have carved out in our Human Rights Act as particularly offensive, and we've given them special protections in civil law, but in some parts of our criminal law we don't have that special recognition. Ironically, we do have that special recognition of the egregiousness of these kinds of assaults when they're motivated by bias for misdemeanor level assaults. But we don't have it in the felony level assaults. And the Anoka County prosecutor indicated that they were not going to charge it out as a misdemeanor because they would end up with a lesser conviction than they thought was appropriate. They chose to charge it out as a felony, but they didn't have the tool to send that extra message that the bias motivation was particularly offensive.
Senator Ingebrigtsen.
Thank you, Madam President. Would the author yield?
He will yield. Senator Ingebrigtsen.
Thank you, Madam President. And Senator, I look at the picture here, and I certainly understand that this is a serious and should be treated as a serious offense. I mean, my goodness, with a beer mug into the face, it can be very damaging, and very clearly it could be something permanent. But if I could, Senator Latz, try and reverse this. I hope I'm eloquent enough to do that. Should somebody be in a restaurant that can't speak English and the waitress were to come up and try and take an order, and there became frustration, whether it be intoxication or whatever, but it became frustration, and with the inability to take the order, the role would be reversed. This person were to grab a water glass and swing at the attendant or the waitress. Would that be a biased crime? Just a point of clarification.
Senator Latz.
Madam President, given the hypothetical, Senator Ingebrigtsen, I would say probably not. It would be a crime based on frustration out of a particular inability to communicate effectively between the two parties, which is different than saying the motivation was because the waitress was perhaps a different nationality or didn't speak the language of the person who was trying to make the order. So I would distinguish that. And I would again add that a prosecutor still has the burden of proof in front of a jury to demonstrate beyond a reasonable doubt that the bias, the intent behind the crime, the reason for committing the crime was because of the person's nationality or the color of their skin or their disability, whatever the case may be.
Is there any more discussion on Senate File 2680? Senator Ortman.
Madam President, will the author yield?
He will yield. Senator Ortman.
Madam President and Senator Latz, what are the current sentences for first, second, and third degree felony assault?
Senator Latz.
Madam President, the current sentence for first degree assault resulting in great bodily harm or use of deadly force is 20 years. For second-degree assault is 7 years if a dangerous weapon was involved, 10 years if there was a dangerous weapon and substantial bodily harm. And for third-degree assault, it's 5 years if there's substantial bodily harm or some other criteria are met.
Senator Ortman.
Thank you, Madam President. And Senator Latz, that's my point. It is already a severely penalized crime. It's a felony. And a first-degree felony is subject to a service of up to 20 years in prison. And at the same time that we are looking at sentencing reform, I'm wondering why we're going to try and add 25% of the sentence on top of that. I, for one, can't agree with that. I think 20 years imprisonment as a mandatory sentence for first-degree felony is sufficient to convince anyone not to engage in assault in Minnesota for any reason.
Senator Herr.
Madam President, I rise to support this bill. I know there's a mutual respect of all of us to appreciate or be respectful for other people who are new to our country that's still catching on learning English and having problems speaking English, so they have to rely on speaking in native tongue. So mutual respect for one another. The mutual respect should start early on in the young days. Mutual respect should take the teaching of the parent or from teacher or from school principal. And I'm saddened that in our state, our governor has to be our point as adult. Our governor had to come out and make a statement for all of us as an adult citizen of our country. And I'm grateful that our governor did that as well. I'm sure the similar thing happened in other states. I won't name them, where elected officials turn away from issue like this and didn't stand up and make comment address people or citizens in their state about the proper way of accepting new members to our state. And I want to address to people of Minnesota and also fellow member of this chamber that America shouldn't worry about people not wanting to speak English. English is the language of success. The whole world speaks English. Everybody's just trying to catch on. We are at the place where we are still worried. My nephew, my next generation, we're still worried that they're not going to be able to speak their native language. And people who come from other countries, this may be the only haven that they can practice their own native language. They may be killed in their own native country if they speak their native language. And so this is the only haven that they can do that. I'm so glad that I'm in this country of the United States of America where indigenous people of other countries are here and still can maintain their own native language. And so, yes, English is a language that we have to speak here, but at the same time. Let's not be hateful toward people who have to use their own language to get by. So I'm right to support this bill. Thank you.
Senator Dibble.
Thank you, Madam President. Madam President, I wanted to thank Senator Latz for bringing this bill forward and giving us the opportunity to remedy some of the deficiencies that we've discovered in our hate crimes laws with this incident, as well as another one that occurred in Minneapolis recently. Members, let's remind ourselves that we make distinctions and discernment around charging decisions that relate to crimes that are committed all the time, based on circumstances, based on mitigating circumstances, based on aggravating circumstances and the like. We look to motivation, we look to prior convictions, et cetera, when we make some of these charging and conviction decisions. We all have a stake in an effective response to bias, especially when it turns violent. And the biggest reason, of course, has already been articulated well by Senator Latz, that when there's damage done by a hate crime, it's not measured solely in the terms of its effect and impact on that individual, but it has a much broader impact on our society and on other members of those minority communities. Makes them feel intimidated, makes them feel isolated, can add to greater tensions in our community, it can give rise unaddressed when justice isn't delivered to folks who are marginalized and not well supported by the system, give rise to greater tension and even give rise to other crimes of its type. When we make minority communities members of suspicious groups and violence is perpetrated against them because of those reasons, and there's not an effective response to that, that gives some sort of tacit admission on the part of the system that that is all right. And I've seen that happen, of course, time and again, perpetrated against my community when there is no effective response to bias and violence against our community. It sends a signal to those who are inclined to commit those kinds of crimes that that's all right and they can do that. Members, this is an important repair to a deficiency in our laws so that we don't see incidents like this further damage the cohesiveness and coherence that we need with the diverse society that we live in. Thank you.
Is there any more discussion? Seeing none, the Secretary will give Senate File 2680 its third reading.
Senate File Number 2680, a bill for an act relating to criminal justice, increasing the maximum penalty for felony-level assaults motivated by bias.
Secretary will take the roll. All members having voted that desire to vote, the Secretary will close the roll. There being 40 ayes and 19 nays, the bill is passed and is title agreed to.